know up front when we state the appearances. So we'll go ahead and call the first case if you want to come forward, which is 128-144, Ebby versus Pistotnik. If you'd state your appearances, please.
May it please the court, Stephen Brave appearing on behalf of the appellant, Bridget Eby. And with your honor's permission, I would request 3 minutes for rebuttal.
Okay, 12 and 3.
Good afternoon, may it please the court. Richard Olmstead appearing on behalf of the defendants, Tony Atterbury, Brad Pistotnik, and Brad Pistotnik Law PA.
Okay. Well, as I think both of you know, we are provided with a lot of information in advance. So we have read the briefs, pre-hearing memos prepared by our research attorneys, some of the pertinent documents. So the time is yours, but if you want to get straight to some of the legal arguments, so that's fine. Or if you want to advise us of some facts you want us to focus on, that's fine as well. So you may proceed.
Thank you, Your Honor.
You're welcome.
As the court knows from reviewing the pleadings and the underlying court file, this is a case that basically stems around a single issue. Was the plaintiff's expert, Ms. Anna Upinen, qualified to offer the legal opinions that she did? The evidence is undisputed that she is a licensed lawyer, has been for over a decade, has experience as a prosecutor in private practice, done a wide variety of things. The plaintiff's position is clearly under KSA 6456B, her education alone qualifies her as an expert able to offer an opinion on a legal subject.
How can that be? That would mean everybody who graduates from law school would be qualified as an expert. Is that your position?
It is, and I would submit to the court, authority for that isn't in any Kansas case that addresses lawyers. But there is a case, Glassman versus Costello, which is 267 Can 509, that held exactly that. In that case, 2 pathologists offered opinions about a standard of care that applied to an obstetrician, even though the pathologist had never done any obstetric work. The district court struck their testimony. On appeal, the Kansas Supreme Court reversed that and said it was error to exclude the pathologist's opinion testimony, and specifically said it was never intended, that being the statute governing the admissibility of expert testimony, to limit admissibility of opinions by experts who are within the same profession or who hold the same basic licensure. In other words, any doctor can offer an opinion. They are qualified as an expert. Whether it's reliable, whether it was based on sound scientific principles or the rest of the analysis is a separate issue.
So you're saying it goes to the weight, not the admissibility?
Absolutely. I mean, she would get, or she's qualified. I mean, I think that's a given. She's a licensed lawyer with experience. She's dealt with cases involving experts. She knows the statute. She knows that if you have a case that requires an expert, obviously, her opinion was, you need to consult with an expert, get them on board to successfully pursue the case. Failure to do that in any area of the law is probably going to end up being, a breach of whatever standard of care applies to a reasonably competent attorney in Kansas.
So if the court said no, why didn't you just go hire another expert?
Because my expert deadline had passed. This all happened at the same time we did the summary judgment motion.
But couldn't you ask leave to hire another expert?
No, at this point, I had disclosed my expert, the defense had disclosed theirs, discovery was closed, we were past that.
I understand it's closed, but I've also seen it be reopened.
Yeah, that was not requested. I didn't think there was any possibility that that would occur. Instead, we relied on the defendant's expert, Mr. Finnerty, who also offered the same standard of care opinions that Ms. Upinen did. He simply said she didn't, or the defendants didn't breach the duty by not consulting an expert, not designating an expert, and basically abandoning their client. So by the time we got to the summary judgment stage, we had been through pretrial, everything had been done. I mean, I would have had to restart the whole case. And I didn't think there was any possibility that that would ever be granted. This case had gone on for a long time. The expert deadline was long past. The discovery deadline was long past. Everyone had been disposed.
And you never thought there might be an issue with her being an expert in this kind of a case when she'd never done one?
She's never acted as an expert.
Well, I don't think she was ever an expert, and I don't think she'd ever done a personal injury case.
Under the statute, like I said, if someone has the education to know what the law is, and she knows that you need an expert, which was undisputed, and their own expert agreed with her, she's absolutely qualified. The fact that she hasn't done a personal injury case doesn't mean she doesn't have the qualifications to be an expert in the law. And again, that goes back to Glassman v. Costello, and when we're dealing with the statute, which is plain. 6456 doesn't say an expert has to have direct experience in the same area that they're offering an opinion on. Simply says you're qualified by any number of ways: experience, education, training, skill, or knowledge. Ms. Upton had tried cases herself where cases involved an expert, understood how that worked, understood discovery deadlines, understood the elements that needed to be proven. How was someone able to work as a prosecutor for close to a decade, do major felonies, off-grid felonies, and is unable to testify about what the standard of care is in a personal injury case? There's no law that says that's what you have to do, and it's clearly contrary to 6456. But if the legislature had wanted that to be the law, we know that they are aware of how to do that. The court only needs to look at KSA 603412, where they did exactly what Your Honor is suggesting. In order to qualify as an expert in a medical malpractice case, you have to spend at least 50% of your time as a physician, not in a subspecialty, just as a physician in general. And again, that goes back to the Glassman v. Costello case.
So that, I'm trying to refresh my recollection on the med mal. It has to be a certain amount of time in clinical practice.
In actual clinical practice, yes, sir. 50% of their time has to be spent actually doing medicine, but it can be in any area. And that's Glassman v. Costello. There's also a case, Whisker versus Hart, which is 244 Cam 36. That one says a general practitioner was able to testify about the standard of care applicable to surgeons. Also advise the court as to Tompkins versus Bice, B-I-S-E, 259 Cam 39, where that one is kind of an outlier because it involved a dentist who wasn't even licensed by the Kansas Board of Healing Arts being allowed to offer an opinion about oral surgery. That was perfectly fine. Why should a more stringent standard apply to attorneys who don't have a statute like 603412? Well, it does apply to doctors. You end up with kind of a dual standard, and the statute doesn't distinguish between professions. Someone that has the knowledge and experience and education to know what the law is an expert. It was therefore error for the district court to disqualify her from offering any opinion whatsoever. She wasn't even free to testify as to an attorney has a duty to reasonably investigate a case. How is that somehow improper, or she's not qualified to offer that? I think that's something that probably falls within the common knowledge exception. I think everybody knows when an attorney's hired, you need to look into the case. Same way with an expert. If you're a licensed attorney, you've been in practice, and you know that you have a complex issue, such as the diagnosis of an STD, everybody agrees. You've got to get an expert. Not only to testify, but her opinion was you need someone that can guide you through what the applicable medicine is so that you know what to look for as you litigate the case. That applies across the board. Criminal cases, family law cases, tax law cases, you need an expert. The only way to get it in is through an expert. You can't put your client up there and have them testify about what they think the applicable medicine is or what the standard of care is. So,
Now, was the summary judgment, I mean, I know these are interrelated, was the summary judgment based solely on the lack of expert, or was there any other reasons?
my argument is yes. Once Ms. Upinen was disqualified as an expert, the whole case went away. I mean, that undercut everything because we didn't have the necessary opinion testimony. The district court did make a bunch of additional factual findings. I don't know why those were made or what relevance they had.
Well, part of, you know, we used to deal with Fry, now we deal with Daubert, and some of that's probably gatekeeping type of things. Does that impact the analysis now being under Daubert, that the district court performs a gatekeeping role for experts?
In this particular case, I don't think it does, because no matter how you look at it, the district court was required to apply 6456. The interpretation of a statute is always going to be de novo review. So I don't know that you really get past that, because once he disqualified Ms. Upinen, like I said, everything went away. And kind of the tricky part was, I think kind of getting to the point you're heading to, is if the district court had gone through those additional factors that are in subsection B and said she didn't have sufficient facts, or she didn't, her testimony is a product of unreliable principles. If he had done that analysis, then we would be up here and we would have something to chew on, and I could argue, you know, this is reliable. I mean, what she said was fundamental practice of law, but he never got to that point. And no one's ever said that those three factors in subsection B weren't met by her. And as I mentioned before, their own expert agrees. In this case, the defendants would have known they needed an expert from the jump. They would have known they had the duty to investigate. All those things. There was no dispute over those things. So, I mean, we're asking the court to reverse the lower court's decision on granting Pistotnik summary judgment, and on the flip side, Ms. Eby's motion for summary judgment should have been granted. That was properly, when you include Ms. Upinen's opinions, it was properly written, it complied with Rule 141, everything was cited. The response did not comply with Rule 141, had endless objections to things that had been admitted in the defendant's answer. Things that had been fundamental and long well known, they objected and simply didn't respond to it. So we're asking the court to reverse the decision granting the defendant summary judgment, and also reverse the decision denying Ms. Eby's motion for partial summary judgment on the existence of a duty to exercise reasonable care, as well as the KCPA claims.
So let me ask, from your briefs, it seemed to me that you were conceding that if we affirm the expert's disqualification, then summary judgment was properly granted. Is that correct?
Yeah, I think, you know, Mr. Finnerty did agree on a lot of the standard of care, but the causation element only came from Ms. Upinen. So yeah, if you disqualify her, then I suppose arguably you could have the causation issue go to the jury, because that's normally a fact question. But here I think it would have to be supported by an expert opinion.
Thank you.
Thank you.
Thank you.
Olmsted? You may proceed.
Good afternoon, and may it please the court. I intend my comments today to be brief and address only three issues. Of course, if the panel has additional questions for me on the issues that were raised in our brief that are not addressed today, I'd be happy to answer those. The first of those, I will briefly address the standard of review applicable to the decision to disqualify Ms. Upinen. Mr. Brave, during his remarks, indicated that the standard of review was de novo because a statute was reviewed. There was no statute reviewed. The Kansas Supreme Court in State v. Aguirre, 313 Can 189, addressed this exact issue and said that both when assessing how the district court performs its gatekeeping role and whether or not to allow in expert evidence, we apply an abuse of discretion standard.
So in a way, it sounds to me like it's somewhat of a mixed standard of review, to the extent of certainly the statute controls what an expert's general qualifications are, but then we apply Daubert to see whether it's reliable underneath the statute.
If you get to that second phase.
Okay.
This case was decided at that first step.
Okay,
And what the panel of this court in Smart versus Burlington Northern Santa Fe said, and this was adopted by the court in Aguirre, is it says that to determine whether the court adequately performs its gatekeeping role, we look to decide whether the expert is qualified. The court must look to decide whether the expert is qualified by knowledge, skill, experience, training, or education to render an opinion. And that is precisely what the district court did in this case. It considered the briefs of the parties. It ordered a KSA 6, or it didn't order, it held a KSA 6247 hearing and heard arguments of the parties. Ms. Jumpinen was not called to testify at that hearing, and then it issued an opinion based on the evidence presented.
Well, why wouldn't your opponent's position be correct? That if you've gone to law school, you're an expert in the law, you've got 10 or more years of practice as a prosecutor and other things, why isn't that sufficient to speak to a basic standard duty of care for an attorney?
A couple of reasons, and I'll start with the most obvious, and that's because the Kansas Supreme Court has told us that it doesn't work that way. Starting in 1984 with Bowman versus Doherty, the court held, quote, "The duty of an attorney to exercise reasonable and ordinary care and discretion remains the same for all attorneys. But what constitutes negligence in a particular situation is judged by the professional standards of the particular area of law in which the practitioner is involved." After Daubert, which was decided in 1993, we have multiple cases from both this court and the Kansas Supreme Court citing that specific provision of Bowman versus Doherty with approval. The first of those was Zimmerman versus Brown, which is a Kansas Court of Appeals decision. Then Bergstrom versus Noah, 266 Can 847. The Supreme Court cited Bowman, once again, in affirming the holding at the district court level that disqualified the plaintiff's attorney because of his, quote, "lack of expertise in the area of antitrust law in the Kansas statutory law upon which," end quote, "the plaintiff's lawyer proceeded in the underlying litigation." And then finally, this court, in an unpublished decision, which is cited in our briefs, the law office of Ross D. Alexander versus Brown, applied that same reasoning. In that case, Mr. Brown was a licensed Kansas attorney. He was going through a divorce and hired Mr. Alexander to represent him. During the course of the divorce, there was a dispute that arose over fees. Mr. Brown ended up suing Mr. Alexander for malpractice, and the court disqualified Mr. Brown and held that even though he is a licensed Kansas attorney, because he had no experience in domestic cases, he was not qualified to be an expert on the standard of care in a domestic case.
So do we really have a different standard for expert attorneys as lawyers as compared to expert attorneys in medical malpractice cases?
Well, in medical malpractice, it's a little different because there's a separate statute that applies, 643102. So there's a little different standard in medical malpractice that doesn't apply in this case. But the standard for lawyers is clear according to the Supreme Court. And it's not just Kansas authority. Authority from all over the country holds the same thing. I cited several of those in our brief. I think the most notable that I'd ask the panel to consider is Butler versus First Acceptance Insurance Corporation, which is a Georgia case, Georgia federal case, out of 652 F sub 2nd 1264. And in that case, an incredibly experienced attorney, 30 plus years of litigation experience in personal injury cases, the co-author of the Georgia Handbook on Litigating Personal Injury Cases, was found to be disqualified in a tortious failure to settle case because he lacked experience in that area. The court applied the exact same reasoning that the district court in our case applied and held that the witness wasn't qualified. But here, it wasn't just Ms. Jumpinen's lack of experience, any relevant experience, that rendered her unqualified to present an expert opinion. It was also her lack of education that provided the specialized knowledge necessary to be an expert under KSA 6456. I asked Ms. Jumpinen about her legal education and what she remembered about it to find out how her legal education supported or informed the opinions that she offered. And the only testimony she could give me is that the only thing she remembered about her law school education was that she wanted to get out of there in a hurry. We,
Well, I think we can all agree with
Yeah,
that.
join the club.
I graduated 42 years ago today.
Today.
So.
we asked about authority, legal authority upon which Ms. Yumpinen arrived or relied upon to reach her opinions. She could identify none. She said that she had to learn the law.
Say that again.
She identified none.
No legal authority. that
No
she
legal
relied on.
authority. None.
Thank
Asked her, excuse me, I got sidetracked. She couldn't identify legal authority. We asked her to explain how her experience counseled her opinions. She couldn't explain that. Plaintiff has the burden to prove that her expert is qualified. When it comes to her education, there is nothing in the record for the panel to base its decision on. There's no transcript. There's no testimony about what courses she took in law school, how she performed in law school. The fact that she passed the bar doesn't necessarily make her an expert on civil litigation. We don't know what questions were asked on the bar that year. There's zero evidentiary record that would say what Ms. Yumpinen's education was, and from her own testimony, she certainly doesn't remember it.
Would you say that somebody who's been to law school is, in the eyes of the public, maybe an expert in the law, but that's not what the statute requires?
I think I would agree with that, and anyone that holds a law license would know that every family member they have calls them and thinks that they should know everything about the law. But I think we also have that shared experience where we, who are humble enough to admit it, will say, that's an area of law I don't practice in, and it would be foolish for me to venture into that area and offer an opinion. That foolishness is why we're here today. The question is, did the district court abuse its discretion when it found Ms. Yumpinen unqualified? And the answer to that should clearly be no.
Well, how do you respond to the argument that Mr. Brave made that, yeah, these are, he didn't say this part, but these are good arguments you're making, but basically that goes to the weight to be given this expert and not the admissibility, that she should be allowed still to testify, and then you can challenge, undercut her qualifications at will.
Well, one, I think that runs counter to the authority that I've discussed today and that's cited in our opinion, or in our brief, excuse me. And two, I don't think the law should be, so long as somebody is brazen enough to offer a foolish opinion that they're not qualified to offer, we should go to trial. My client shouldn't have to suffer the expenses and time and frustrations of a trial simply because of the argument that, hey, you can prove that she doesn't know what she's talking about at trial. We proved that she didn't know what she was talking about in her deposition and in our briefing. And then the last issue, Your Honor, is I don't think it matters. And that's because even if she were found unqualified, there is no evidence of proximate cause.
You mean even if she were found qualified?
Qualified, excuse me.
Okay, thank you.
And her opinions allowed. And that's because the three proximate cause opinions that she offered are all barred by collateral estoppel, the law of the case, or Ms. Eby's prior sworn testimony.
Well, law of the case changes as the case goes along unless you have an appellate decision that sends it back. So what do you mean by law of the case
It is
here?
the prior appellate decision in
You
this
are referring to
case.
that. Okay, got it.
Yes,
Got it.
I am referring to the prior decision of this panel, and I'll address each of those three opinions. The first opinion Ms. Yumpinen offered on causation is that Ms. Eby relied on negligent advice from Mr. Atterbury in choosing to settle the underlying litigation. But Ms. Eby has repeatedly testified under an oath that she didn't even think she was settling the case when she signed the settlement agreement. And we've provided in our brief multiple citations to the record from the underlying case and from this case where she has confirmed that that is in fact her testimony. In the prior appeal, Eby argued the exact same thing. We relied on bad advice. It was the bad advice that's the negligence, and that's where our harm lies. And this is what the court said in that appeal. In the prior appeal, she argued that she did not simply up and decide to settle. Instead, her decision was based on legal advice and counsel provided to her by the defendants. The problem with this strategy
is that her legal arguments in the summary judgment pleadings and on appeal are contrary to her own testimony. She cannot advance a legal argument to avoid the application of collateral estoppel that is contradicted by her own testimony. And that was at page 5 of that unreported opinion. The next opinion that Ms. Yumpinen offered on proximate cause was that Ms. Eby lost her ability to proceed to verdict in the underlying litigation because the defendants did not make sure she clearly understood the settlement agreement that was being signed. That too is foreclosed by a different decision of this court. In BE versus GG, and that's an unreported case, 2018 Westlaw 4167678, the court held, as its finding, Ms. Eby understood the agreement and knowingly agreed to mutually dismiss all pending claims. As a result, she's collaterally estopped from advancing that opinion for Ms. Yumpinen. And then finally, Ms. Yumpinen's proximate cause opinion was that Mr. Atterbury somehow entered into the settlement agreement without her knowledge or consent. This also is foreclosed by this court's prior opinion in this case, where the court held Ms. Eby is collaterally estopped from arguing that she was harmed because her counsel verbally agreed to dismiss the prior lawsuit without her approval. And that's at page 12 of that unreported opinion. Therefore, even if she hadn't been disqualified, all of the causation opinions that she offered are barred. They're inadmissible, and therefore there was no evidence at summary judgment that the court could have looked to deny the defendant's motion for summary judgment. Summary judgment must have been granted based on the absence of any evidence of that essential element of her claims, the proximate cause element. Unless there are further questions, I have nothing else.
Well, I do have one question, and that is, what are we to do with the Kansas Consumer Protection Act?
That decision rises and falls with the malpractice decision. And again, we can go back to the court's prior decision in this case.
Okay, well, I just wanted to make sure that we knew what your position was. I mean, I know what's in the brief, but basically it just falls back on the same argument.
Right. This court previously said on remand, if she's able to establish enough for her malpractice claim to survive, then her KCPA claim survives. But if she is unable to establish that her malpractice claim survives summary judgment, the defendants are free to raise the fact that she's not an aggrieved consumer under the statute, and that's precisely what we did.
Okay, thank you, Counsel.
Thank you.
Mr. Gray, rebuttal?
Thank you, sir. I'd like to start with Mr. Olmsted's reliance on the Butler versus First Assurance case out of Georgia, because that highlights exactly what the issue is. In that case, there was highly esteemed, highly credentialed attorney who offered an opinion, but it wasn't a legal opinion. He offered an opinion about the standard of care that applies to claim adjusters when he had no knowledge of, he'd never been a claim adjuster, hadn't worked for an insurance company, didn't know what that was. He wasn't disqualified as a lawyer expert. He was disqualified as someone able to criticize a claims adjuster in a
Settlement
bad
of an
faith,
insurance claim.
right, a bad faith claim.
Yeah.
So that's how that came about. And going back to the standard of review, I mean, Mr. Olmsted admitted, and his argument is, unless you have direct experience in a particular subspecialty of law, you cannot possibly offer an expert opinion. That's a de novo standard of review because you have to go back to 6456, and experience is one of 5 factors. You can't just say, we're writing out the other 4 factors, and we're gonna ignore them unless you have direct experience. You have to look at the entire statute. No panel, no Supreme Court decision that I've ever been able to find ever found any part of 6456, either A or B, ambiguous. That somehow requires us to kind of fill in the gaps.
But don't you think that courts commonly require experts to be specialized in a particular area that they're testifying about?
No.
You don't think that this expert statute then is routinely misapplied?
You mean this one that applies to the doctors?
No. Our regular statute 6456.
think you have to be, you can be a professor, oops, never practiced medicine, never practiced law. I mean, I think you know the basic duties of a lawyer. If she had offered an opinion that was off the wall and didn't have any support in the law, that's a separate issue.
No, I'm just talking about qualifications. I'm not even getting into what her opinion is.
Sure,
I'm
I
just
think-
talking about establishing somebody as an expert witness in a case. Do you think 6455 is commonly misapplied?
No.
Because it seems, in my experience, the judges do require the expert to have specialized experience, training, et cetera, in that area.
But it's just like the Glassman case. If you're a doctor and you have a medical degree, you're free to offer opinions about any specialty. Then you go to the second step. So, I mean, I think that line of cases that addresses the physicians and what they're free to opine upon. I mean, you can take a general practitioner, they can offer an opinion about a neuroradiologist. That is established law from the Supreme Court, and there's no indication that they ever plan to change that. I think all those cases are from the 90s, and they've never been overruled. If you're a doctor, you have the requisite foundation to be an expert. That gets your foot in the door. The second step is usually where, under Daubert, things get trickier, because you have to see if it's a valid opinion, is this completely harebrained? But just merely having the licensure, that's the words used by the Supreme Court in Glassman. The license itself qualifies someone as an expert free to opine upon a medical issue. Same rule should apply to lawyers. Again, if the legislature wanted a different rule to apply, they would have enacted a statute that did whatever they wanted. They haven't done it, so there's no reason to not apply 6456 as written. And we would ask that you afford Ms. Evie the relief she's requested. Unless there's any further questions, that's all I've got.
Thank you.
Thank you both. We will take this case under advisement to get an opinion out to you as soon as possible.